Hi everybody, welcome back. Glad you could tune in again. Okay, something a little bit different in this video. A number of folks in the last few months have asked for some comment or feedback or input on the subject of the recent Supreme Court ruling, Bostock versus Clayton County, which has some quite significant implications for how sexual orientation and gender identity are viewed in American law. And this is not really daily devotional material, not least because I suspect this video might be a little longer than I'd want daily devotion to be. And it's also somewhat complex, but I do think it's important. And one of my hopes is not just to clarify a little bit what the decision was and what its implications might be, but to if you like, put into practice some of the stuff that I have been trying to talk about in some recent devotions about how we handle disagreements. There are certainly going to be a number of points here where we would want to respectfully disagree with a number of the Supreme Court justices, but there are some important principles, I think, to bear in mind about how we go about understanding what they've actually said. So I'm not a legal expert, and this is, I embark upon this with a degree of trepidation. I make no claim to be able to interpret the law in any kind of authoritative way. But on the other hand, I can read, and the Supreme Court publishes all of its findings, and it's possible for anybody just to download that stuff and look at it. And so I wanted just to show you how I've gone about trying to understand it. It may be that at one or two points you think, oh, I've not quite read that right. Absolutely fine. Give me a shout, and I'm very happy to talk about that. It's very possible that I've misread something or missed something out that's significant. But at the very least, I wanted to show you how I, as a non-legal expert, would go about trying to understand such a complex decision as this, and then offer some thoughts from a biblical perspective about what we might learn and what we might need to do in the light of this. Okay, so the background will be very familiar to everybody. The issue concerns a number of cases that came before the Supreme Court, which were all rolled together under one heading, Bostock versus Clayton County, and all of the cases involved people who claimed unfair dismissal on grounds related to the 1964 Civil Rights Act. Now, what the Civil Rights Act says, and you know this perfectly well, is that it outlaws, quote, discrimination based on race, colour, religion, sex, or national origin. And in particular, in relation to these cases, all rolled together, Bostock versus Clayton County, Title VII of the Act focuses on equal employment opportunity. And what happened in this case was that the issue of discrimination on the grounds of sex, which you and I might think refers to male and female, well, that's part of the question, came to the forefront, and a number of people who were dismissed on the grounds of sexual orientation or gender identity, transgender people, claimed unfair dismissal citing sex as the grounds for their dismissal, and therefore claiming protection under the Civil Rights Act. And the Supreme Court agreed with them by a majority of 6-3. So what I want to do is, really do what anybody ought to do before making any serious comment, even in a restricted public forum like this, and just to read the rulings. I want to read through a few bits with you. I think methodologically here, there's an important point to be made. It is not always necessary for us to read everything that comes out of, let's say, the Supreme Court before forming an opinion on it. There are 170 odd pages of this judgment with all the different opinions from different groups of judges. On the other hand, I do think it is necessary to make sure we have as reliable a source of information as possible, especially if we're planning to make our opinions public in any forum, or if we're planning to make decisions on the basis of what we think that would affect other people's lives. So if you're an employer, obviously you'll want to have really, really top quality information about what this decision means, and you wouldn't want to just rely on stuff that you're reading in the newspapers and online and so on. And I tend to be a little bit sceptical about the mainstream media and social media anyway, and I think with good reason. So my inclination is to do what the reformers and their humanist predecessors did before them, and just go back to the sources and read what the actual documents say. And there are, there's a fair pile of stuff here, but I'm not going to read it all, so don't worry. I've been through it, and I wanted to draw out a few things which I hope will be helpful. There's a majority opinion authored by Justice Gorsuch. Then there are two dissenting opinions, one Justices Alito and Thomas, and the other from Justice Kavanaugh. And I want to just go through the things that the majority opinion and the two dissenting opinions say, and then make some comments from a biblical perspective just towards the end. Okay, so let's pitch straight in. Okay, here is the syllabus and opinion of the court, which is authored by Justice Gorsuch. And it begins, in each of these cases, an employer allegedly fired a long-term employee simply for being homosexual or transgender. And it recounts Title VII of the Civil Rights Act, which, quote, makes it unlawful for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual because of such individual's race, colour, religion, sex, or national origin. And obviously, in this case, the plaintiffs were highlighting the mention of sex as a grounds for discrimination. You may not discriminate on the grounds of sex. Now, importantly, quote, the parties concede that the term sex in 1964 referred to the biological distinctions between male and female. That's important. They don't think they're redefining what the word sex, as in male or female, means in the Act of 1964. They want to do something else, and that's actually where the judges agree with them. But in summarising the implications of this Act, Justice Gorsuch writes, an employer violates Title VII when he intentionally fires an individual employee based in part on sex. It makes no difference if other factors besides the plaintiff's sex contributed to the decision. So that's the summary of the judgment. Now, how did they reach the conclusion that these individuals who had been dismissed because in some cases they had come out as gay, in other cases they were transgender people wanting to live and to present themselves as the opposite biological sex to what their actual biological sex is? How did these justices end up applying a law which is about male and female sex to transgender or sexual orientation? Here's how it goes. And this is quite important to understand the structure of what these guys are saying. Quote, it is impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Notice, they're not saying that discriminating on the grounds of gender identity or sexual orientation is the same as discrimination on the grounds of sex. They're saying that it always involves discriminating on the grounds of sex. And you're thinking, how's that possible? Well, read on and it explains. Consider an example. An employer with two employees, both of whom are attracted to men. The two individuals are, to the employer's mind, materially identical in all respects. That's an important phrase we'll come back to in a few minutes' time, but for now we'll just leave it. Except that one is a man and the other is a woman. If the employer fires the male employee for no reason other than the fact that he's attracted to men, the employer discriminates against him, for traits or actions it tolerates in his female colleague. In other words, you're allowed to do this if you're a woman, but you're not allowed to do this if you're a man. I'm going to fire you. And so Justice Gorsuch and the other co-authors of the majority opinion say, actually what's going on is discrimination on the grounds of sex. Because you let a woman do this, why won't you let a man do this? Or, to take another example, take an employer who fires a transgender person who was identified as a male at birth, but who now identifies as a female. So no other changes, they just identify, whatever that means, claim to be female. Quote, if the employer retains an otherwise identical employee, another important phrase which we may come back to in a moment, who was identified as female at birth, the employer intentionally penalises a person identified as male at birth for traits or actions that it tolerates in an employee identified as female at birth. Again, the individual employer's sex plays the individual employee's sex plays an unmistakable and impermissible role in the discharge decision. In other words, if an employer sees that somebody, a man in this case, is attracted to men, a homosexual man, or identifies as a woman, a transgender person, and starts to act or to speak or identify in either of those ways, and dismisses him on those grounds, he's dismissing him for something that he would have no problem allowing a female employee to do. That means that discrimination on the grounds of gender identity or sexual orientation necessarily entails, in Justice Gorsuch's opinion, and the other 5 justices who co-authored the paper, discrimination on the grounds of sex. Now, the employers obviously had some things to say in reply to this, and I want to go through 5 of the things that they said by way of response. To begin with, they articulated what you might call the ordinary conversation argument. They pointed out, quote, discrimination on the basis of homosexuality and transgender status aren't referred to as sex discrimination in ordinary conversation. You and I can tell the difference, and we talk about these things in different ways. We talk about discrimination on the grounds of male or female, and we talk about it on the grounds of gay or straight. And we might even talk about it on the grounds of cis or trans, if we're willing to embrace that slightly strange vocabulary, but there it is. But the justices continue, these conversational conventions do not control Title VII's legal analysis. But that's something which is contested, in effect, by some of the other justices, who insist that, no, it jolly well does matter, because the purpose of an act is to put into legal terms what ordinary people would understand by its words at the time it was written. But the majority justices dispute that. They say it doesn't matter that we wouldn't normally speak of things in this way. Second, the defendants, that is the employers, say it wasn't their intention to discriminate on the basis of sex. They weren't trying to discriminate against these individuals because they're male or female. They actually wanted to discriminate on the grounds of gender identity or sexual orientation, and that's permitted. The justices reply, it doesn't matter. It doesn't matter whether you intentionally discriminate on the grounds of sex. If you actually commit an action which entails discriminating on the grounds of sex, you've still broken the law. An analogy, and I think I read this in here, would be with somebody who commits arson. Somebody who burns their neighbour's house down is guilty of arson. Now, if the reason they're doing it, their intention, is just to give themselves a better view, they're still guilty of arson. They've still burnt their neighbour's house down, and it's still against the law. The fact of their intention not being to destroy their neighbour's property is irrelevant, because in effect they do destroy their neighbour's property, whether they're intending to or not. Third objection from the employers. They point out the simple fact that sexual orientation and gender identity just aren't mentioned on the Act of 1964. Title VII mentions sex, and it means male and female, and we all agree about that, but it doesn't mention sexual identity. It doesn't mention sexual orientation, and it doesn't mention gender identity. How could it? Because it was almost never, if not just never, spoken about in those terms at that time. But, and here's the response from the justices, we agree that homosexuality and transgender status are distinct concepts from sex. But as we've seen, discrimination based on homosexuality or transgender status necessarily entails discrimination based on sex. The first cannot happen without the second. In other words, they're saying, yep, you're right, it's not written there, but the point of the case is that when you discriminate on the grounds of sexual orientation, gender identity, you are discriminating on the grounds of something that is there, and then therefore your actions are forbidden. Two more objections that the employers raise. The fourth, they point to the implications. They point out that the implications of this are really terrible, and we're going to hear more about this in a second when we look at the minority opinions, the dissenting opinions from the other justices. In fact, what they point out is that this will have the effect of undermining the safety and increasing the vulnerability of precisely the people that the Act was intended to protect, like women, for example. Here's how the objection of the employers is stated. The employers worry that our decision will sweep beyond Title VII to other federal or state laws that prohibit sex discrimination. And under Title VII itself, they say sex-segregated bathrooms and locker rooms and dress codes will prove unsustainable after our decision today. Which you'd think is a reasonable concern, wouldn't you? If you're not allowed to make any distinctions at all between men and women in, let's say, the provision of restroom facilities in schools or in other public institutions, you can imagine the kind of trouble that's going to cause. So how does that bear upon the court's decision? Here's how they respond. None of these other laws are before us. We have not had the benefit of adversarial testing about the meaning of their terms, and we do not prejudge any such question today. In other words, and I think this is probably a legally strong point, but we can all feel the moral weight of the problem here. It's past the soap pontius, really. It's this is nothing to do with us at this stage. We do not prejudge the outcome of those cases, and we'll hear more about the dangers of those cases in the future. Final objection has to do with religious conviction. The employers fear that complying with Title VII's requirement in cases like this may require some employers to violate their religious convictions. So you can easily imagine how that would be, couldn't you? If you're not allowed to, quote-unquote, discriminate against people of a particular gender identity, so transgender people or people who are sexually attracted to members of their own sex, homosexual people, if you're not allowed to discriminate against such people in the provision, in employment contexts, in religious institutions, churches and so on, then that would be problematic, wouldn't it? The judges respond, we are also deeply concerned with preserving the promise of the free exercise of religion enshrined in our Constitution. Well, good. But worries about how Title VII may intersect with religious liberties are nothing new. We've had these discussions before. And a little bit further down, how these doctrines protecting religious liberty interact with Title VII are questions for future cases too. In other words, just as with objection number 4, so also with this objection, we've had these problems before. Religious liberty and the desire to employ certain people and not others conflicting with rights and civil rights and that non-discrimination legislation. We'll just have to see what happens in the future. That seems to be the response they make. And so in conclusion, they say, in Title VII, Congress adopted broad language, making it illegal for an employer to rely on an employee's sex when deciding to fire that employee. We do not hesitate to recognise today a necessary consequence of that legislative choice. An employer who fires an individual merely for being gay or transgender defies the law. So, that's the opinion of the court, which authored by Justice Gorsuch and supported by 5 other justices. Okay, right, so there were 2 dissenting opinions, and I want briefly to look at these because they offer some insight on how some great legal minds would respond to those claims. And then I'll make some comments, as I said, just a few brief comments about just from my own perspective and trying to think biblically through these things. Okay, so the first dissent I want to touch on comes from Justices Samuel Alito and Clarence Thomas, 2 conservative justices. And here's how they begin. This is very interesting, how they begin. And this is an objection that you may have heard in the more popular press if you've been keeping up with it. Quote, there is only one word for what the court has done today. Legislation. The document that the court releases is in the form of a judicial opinion interpreting a statute, but that is deceptive. Now just pause there a second. What they mean is that the judiciary has crossed a line and become the de facto legislature. You know far better than I do that under American governance and the American legal system involves the separation of powers, the legislature and the judiciary and the executive. And it's not right, not appropriate for, let's say, in this case, the judiciary to start legislating. The judiciary's job is to apply the laws. The legislature's job is to create them.
And so the problem that Justice Alito and Justice Thomas identify is that what actually happened here is that the Supreme Court has smuggled gender identity and sexual orientation under the heading of sex in the 1964 Act, and thus basically redefined what the Act meant. Quote, "Neither sexual orientation nor gender identity appears on that list, the list of the protected characteristics in the 1964 Act. For the past 45 years, this is a very important point, bills have been introduced in Congress to add sexual orientation to the list, and in recent years, bills have included gender identity as well. But to date, none has passed both houses." So here's what's happened. Over the last few years, the last few decades, various legislators in Congress have tried to add gender identity or sexual orientation to the list of protected characteristics. Congress has looked at this and said, no, we don't want to add that. We want the legislation to protect sex discrimination, male or female. We don't want it to provide protection, quote unquote, for discrimination in employment contexts on the basis of these other characteristics. And what the Supreme Court today has done, this is what Justice Samuel Alito and Clarence Thomas says, is basically pushed the legislature to one side and acted as a kind of de facto legislature, giving a de facto rewriting of what the 1964 Act means. Now, that has some fairly significant legal and procedural implications. And the justices Alito and forgive me, Thomas, who wrote the first dissenting opinion, engage with this at some length, and it's worth just thinking about this because I don't know whether this is likely to become significant in future discussions, not just about statutes but also about the Constitution. In the background here are different theories of how you interpret statutes. Basically, and this is something that Justice Gorsuch wrote in a 2019 book entitled A Republic If You Can Keep It, which is a quote from Benjamin Franklin, I think, if you remember that quotation from him. He said, the way you should interpret the law is not by trying to guess at the unspoken intentions of the people who wrote it, and not by trying to allow the meaning of the words to evolve with time. Rather, what you should do is embrace what he calls an originalist and textualist interpretation of statutes. This is something that was outlined more recently by Justice Scalia in 2016. And what's the problem that Justice Alito highlights is that, in effect, the majority have gone against that conviction in this case. What they've done is slipped from originalism and textualism, that is, what was the original meaning and what does the text say, into a kind of evolving view of how we should interpret statutes. Now, the same kind of debates take place occasionally in relation to how the Constitution is interpreted. I'm sure you're familiar with that because of your studies in constitutional history and so on. But Justice Alito is pretty scathing. Here's what he says. The court attempts to pass off its decision as the inevitable product of the textualist school of statutory interpretation, championed by our late colleague Justice Scalia. But no one should be fooled. The court's opinion is like a pirate ship. It sails under a textualist flag, but what it actually represents is a theory of statutory interpretation that Justice Scalia excoriated. The theory that courts should update old statutes so they better reflect the current values of societies. And Alito is really scathing with his conclusion in that paragraph. If the court finds it appropriate to adopt this theory, it should own up to what it is doing. He thinks the court has dramatically changed its whole modus operandi. It is no longer seeking to uphold the original meaning of statutes. It is no longer seeking faithfully to enforce, so to speak, what the text meant at the time it was written. It is now, how did he put it, updating old statutes so they better reflect the current values of society. That, he says, is not the job of the court, it's the job of the legislature. You can see why he's irritated about that. Now, in response to some key arguments that the majority verdict put forth, this is quite helpful. The central argument, you remember, is that if you have, let's say, a man who's sexually attracted to other men, who's materially identical in all other respects to a woman who's attracted to men, and you discriminate against the male employee, you're actually discriminating on the grounds of sex. Well, how does he respond? He says, quote, "The problem with this argument is that the court loads the dice. This is so because in the mind of an employer who does not want to employ individuals who are attracted to members of the opposite sex, quote, this is really important, these two employees are not materially identical in every respect but sex. On the contrary, they differ in another way that the employer thinks is quite material. That is, one is homosexual and the other is heterosexual. In the majority opinion, in other words, what the court had done was to frame its approach to answering the question so that it pretended that sexual orientation didn't matter for long enough for you not to notice, and then what you're left with is a man and a woman who are doing the same thing, quote unquote, and you fire the man, let's say, in this case, and you're not allowed to do that. That is pretty clearly exposed by Justice Alito at this point, and I'm quite struck by this. It's two major methodological problems. One, changing the whole approach to interpreting statute, and second, really a somewhat tendentious framing of the argument in favour of the decision, which you'd think is pretty worrying, and clearly has got Justice Alito worried. Now, just a couple of other points. Just on the historical meaning of that legislation, Justice Alito is pretty clear. In 1964, ordinary Americans reading the text of Title VII would not have dreamed that discrimination because of sex meant discrimination because of sexual orientation, much less gender identity. The ordinary meaning of discrimination because of sex was discrimination because of a person's biological sex, not sexual orientation or gender identity. It just isn't true to say that you can extend the reach of this part of the legislation in that way without changing its meaning beyond recognition in the context of the time it was written. And then finally, Justice Alito highlights the implications which we just noted previously. The potential for this decision to impact other areas of public life is almost endless. He cites a number of examples which have already made their way into court cases. Transgender people in school sports, obviously, college sports, that's going to be a big deal because it already is already. Sex reassignment surgery in state medical plans, quite expensive surgery is obviously possible. And if you're not allowed to discriminate in this way, because it's sex discrimination, then is it likely, therefore, that all state medical plans will be required to pay for it, which means that something awful is going to happen to your and my medical insurance premiums? Gender-neutral bathrooms in schools, issues with transgender prisoners, you know, a fairly burly man identifies as a woman and you may not discriminate against him, and so on and so forth. And here's how Justice Alito responds to the claim that that's for another day. Although the court, he says, does not want to think about the consequences of its decisions, we will not be able to avoid those issues for long. The entire federal judiciary will be mired for years in disputes about the reach of the court's reasoning. Well, law preserve us if that's true. Final conclusion. The court itself recognises that the place to make new legislation lies in Congress. We're supposed, paraphrasing now, simply to apply the law as faithfully as we can in the cases that come before us. And he says, in conclusion, it is easy to utter such words if only the court would live by them. I respectfully dissent. So those two major arguments with the buttressing historical points seem to me fairly sharp and non-legal expert, fairly compelling. So now we come to the second dissenting opinion. This is Justice Kavanagh. It's about the same. In fact, no, it's a little bit longer than Justice Alito's one, but we don't need to look at it in great detail because he makes a lot of the same points that Justice Alito and his colleague, whom I forget, Justice Thomas. Apologies for that, mates. Here's how he goes. In the beginning, he echoes the key point they make. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination because of an individual's race, colour, religion, sex or national origin. It doesn't mention sexual orientation or gender identity. It's interesting, and this is maybe significant in the future. I'll make a comment on this a little bit later on as well. He seems at least not to disfavour extending Title VII to cover those two aspects of personal characteristics, gender identity and sexual orientation. At one point he says, quote, "The policy arguments for amending Title VII are very weighty." And one wonders what he actually thinks about that, whether that's just a rhetorical stance he's adopting for the purposes of this paper, or whether it's something that he is actually intending to act or vote on in the future. But in addition to what Justice Alito says, he adduces two further arguments at some length, won't go through it all. First, he highlights that the Supreme Court has a long history of following, quote-unquote, the ordinary meaning of a text or a statute. It's no good just to object that ordinary meaning doesn't matter. Ordinary meaning really does matter because that's what the court always does and has done in its long history. And there's also, he says, a long history of the Supreme Court saying that sex discrimination is different from discrimination on the grounds of sexual orientation or gender identity. He cites 10 Court of Appeal hearings involving a total of 30 different judges, and in every single case, every single one of those 30 judges agreed that the discrimination on the grounds of sexual identity, gender identity and sexual orientation is not the same as discrimination on the grounds of sex. So really the argument that the majority have put up doesn't hold water historically. So that takes us to the end of the second dissenting opinion from Justice Kavanaugh. Okay, so what have we got? Let's just draw things together at the moment, and then I'll make 2 or 3 comments about, just from a more personal or biblical perspective, that I hope may be helpful as we're trying to work out the implications of this going forward. Where we are is that the Supreme Court has decided that when an employer discriminates on the ground of sexual orientation or gender identity, they necessarily also discriminate on the grounds of sex, male and female, because they tolerate in, let's say, a female employee action that they are not tolerating in a male trans or male homosexual employee. So even though the 1964 Act did not refer to sexual orientation and gender identity, it nonetheless applies to it secondarily in that derivative way. That's where we are. That's what the court has now decided. So I've just got three thoughts that occurred to me, and these are very much preliminary. I'm sure that there may be other things that I've not thought of, and I'd be very, very happy if you wanted to ping me an email or any other thoughts, share in some other way. The first is that it does seem likely that there will be other cases in the future as this legislation starts to make its presence felt in other areas of public life, school sports, school washrooms, prisons, the health service, all over the place. I'm not sure what we could do about that. I'll come to that in a second. But we've not heard the last of this. And so it's important, at least for us to understand what exactly it is the court has said. Hopefully the last half hour or so has helped with that. Second, I imagine that this will be disappointing for people who had hoped for better from justices that they thought were, broadly speaking, conservative. I know a number of people voted for President Trump in 2016, in part hoping that he would appoint conservative justices who would bring a degree of stability to the court. 2 of the 5 justices reputed to be conservative voted with this fairly radical progressive reapplication of the 1964 Civil Rights Act. If you thought SCOTUS was pretty secure because of a 5-4 conservative majority, it turns out not to be. And what this highlights, I guess, as I'm thinking about us as a church, us as families, us as individuals now, this highlights the fundamental problem with seeking to find security for a Christian or even a broadly conservative worldview within conservative laws. or Christian laws. It's not that conservative or Christian laws are useless. Obviously not. Obviously it's better to have laws that uphold something approximating biblical values than it is to have laws that ride roughshod over them. It'd be a good thing to have laws that didn't change so rapidly in a direction shaped by the whims of a fairly godless culture. It would be nice to have people who adhered to more of the old paths, as one conservative philosopher whose name escapes me, British philosopher who died quite recently, just pointed out it's so much harder to create culture than it is to destroy it. And one of his arguments for a conservative instinct in the whole of public life is that it's just harder to build up than to tear down. And so we should be really, really careful before we tear down. But if you thought that laws could do the job, if you thought even that legal structures like the Supreme Court could do the job when peopled with a majority conservative bench, again, our confidence in that has been somewhat shaken, hasn't it? And here's where the rubber hits the road, I think, for us as Christians. It highlights the crucial point, which you actually see if you look at it from a biblical perspective, that social change can only be initiated and can only be sustained from the bottom up. It can't be initiated and sustained from the top down. In other words, if you want a country to be shaped by scriptural values and a Christ-honouring way of life, we should always take with a grain of salt the notion that the way to achieve that is by voting for or getting into seats of power and influence and authority Christian or conservative-minded people. Unless, and here's the crucial point, unless we are also seeing from the ground up a transformation of society. I'm all for Christian members of Parliament here in the UK, congressmen and senators, and perhaps a 9-0 Christian Supreme Court and President in the United States. Wouldn't that be wonderful? I'm all for that. But we must be clear in our minds that the way that social transformation works in Scripture, and the way that we've seen it not work in this case, is that it relies upon bottom-up transformation of society. In other words, the front line, here's the key take-home point, the front line in the culture war is not Capitol Hill, or the Supreme Court, or Congress. The front line in the culture war, if we're still allowed to use that slightly dated phrase, is your home, your family, your kitchen table, your children, your church, our lives together. And from there going out into the world, our relationships with our friends, our relationships with our neighbours, our Boaz-like conviction and strength of mind and of heart and of character. That's what's going to transform the world. And in the next few weeks, Lord willing, I'm hopeful that we'll have a number of opportunities to start thinking about how this might take place, how we might seek to work towards this more and more self-consciously in practice. We're coming towards the end of one of our current book in the Theology Book Pub, and I'm planning that the next book that we look at will be focused on this topic. And if you wanted to join us for that, it would be really, really wonderful to have you with us and just come along and get involved in that conversation. Pastor Neil and I are going to be leading the conversation. It's going to be a lot of fun, I think, and also I hope very enlightening as we start to think in practice, what does it mean for us to be committed to a ground-up transformation of society? I guess it's the kind of thing that we all know, isn't it? But it's something that we need to remind ourselves of again and again and again, and not take for granted the position we're in, especially as we see things starting to crumble around us. Okay, I think that's enough, and I hope that has been at least a little bit helpful. Please do shout if you've got any questions, any comments. Like I said, that's preliminary thoughts. I'm sure I've missed things out. I'm certainly sure there are other details in the texts and other biblical angles on this which may be helpful. But for now, the Lord bless you, and I hope very much to see you all very soon. Bye for now.